Good morning to all of you. This video is for the law of Torts students. Yesterday I gave you the synopsis of nervous shock or neurogenic shock, a shock which affects your nervous and brain structure. So definitely, even though here no injury, no physical injury, no psychological injury is caused with a stick, stone or bullet, but still you suffer the shock, you suffer the injury. Yes, it is compensatable. Damages can be claimed. So a nervous shock is a reflex response to the passage of electric current through the body. So how it arises? It arises from the imminent fear or apprehension of injury, immediate personal injury. Second, please remember, you must be within the area, vicinity. These 2 points are important. Number one you should have the immediate personal injury, apprehension, fear of personal injury, immediate personal injury. Second is you must be within the area of the incident. These 2 points are more important. Now straight away, this is of recent origin, as I told you. In the first case, we are saying the negative example because the court did not recognize it is a nervous shock. This case is Victorian Railway Commissioner versus Torts, 1888. So please remember, this Torts along with his wife, he was traveling in a horse-driven cart. When they were crossing the unmanned level crossing gate, suddenly an engine, railway engine, came on the railway track, but it has just grazed the horse-driven cart, due to which the wife of the defendant, Mr. Torts, she suffered nervous shock. So, but the Privy Council did not say that it is nervous shock, and they have rejected the claim. So they did not identify that this also can be compensatable. Next, Wilkinson versus Downton, 1897. So this is a case from practical joke. Don't play practical joke. So the question may also come like this. So what is the decided case law on practical joke? So Mrs. Wilkinson, she was a rich landlady, and Mr. Thomas Wilkinson was her husband. So he went to the city for doing something. So she was alone. This Downton, another woman, or I think he's a male person, Downton, he cracked a practical joke to Mrs. Wilkinson, stating that her husband, Thomas Wilkinson, had met with an accident. Not only that, he lost both his legs, and that the plaintiff should go immediately to bring him home. So these statements were apparently false, but the defendant intended them to be believed as true by the so-called practical joke. But what happened ultimately? Mrs. Wilkinson, she suffered nervous shock. So as a result, now she filed a case against the defendant for the so-called actually misrepresentation. At the time, they have filed the case under misrepresentation. But anyway, the court, yes, he held it, recognized firstly regarding the nervous shock. This also, so even though there is no injury, but since he suffered nervous shock, definitely it is compensatable. First case. So otherwise, the main tort of negligence is added to this. Then Hambrook versus Stokes Brothers. So 1925, the mother, she was taking her children to the school, and at a little distance, the children stated that, Mama, mother, you go back, we are just reached the school, we will go away. But what happened? Then she turned this side, she found a lorry coming from the steep upside on the same road, and somebody shouted, "Arey, this lorry is coming in a negligent, the driver is in a negligent manner, it is hitting some person, go away, go away." And he has added that, a bystander added that a person, a child, which are of the similar descriptions of the children of this woman, he also was knocked down by the lorry. She suffered nervous shock. So the defense is that she was not in the vicinity because actually the lorry was coming. The children already went to their class. Nothing happened. But still, because that man was driving the vehicle in a negligent manner, the taxi driver, this man, for his negligence in handling the lorry. So even though the defendant was not within the area of a physical injury, yes, it is held to be nervous shock. ఇందాక మీకు దానికి నెగిటివ్ ఏది విత్ ఇన్ ది విసినిటీ ఉండాలని, ఉండకపోయినా సరే ఈ కేసులో యాక్సెప్ట్ చేశారు. దెన్ కింగ్ వర్సెస్ ఫిలిప్స్ 1953. యాక్చువల్లీ the mother was in the upstairs portion. The boy was playing on the road on a tricycle. So a car came and it has dropped some persons. When it was reversing, this boy went to the back side. అది వెనక్కి వస్తుంది, ఈ పిల్లడు ముందుకెళ్ళి కారులో ఇరుక్కున్నాడు, కారు వెనక్కి వెళ్ళాడు. So I think he suffered some minor injury. Mother saw from the upstairs. She was under the impression, అయ్యో మా అబ్బాయి అయిపోయాడు రా బాబు, కారు వాడు చంపేశాడని చెప్పి she suffered nervous shock and of course she died, I believe. Suffered nervous shock అంతవరకే. So the mother filed a claim seeking damages. Court held that the incident was not within the area. So she is not within the vicinity. So therefore the taxi driver was held only liable for the negligence, that's all. But they need not pay any compensation to the mother. They have to pay compensation only to the child, that's all. Then Bournehill versus Young. Actually ఈవిడ మిస్ యంగ్, ఓకే, ఈ యంగ్ అనేవాడు ఏంటంటే ఈ వాజ్ డ్రైవింగ్ ఎ మోటార్ సైకిల్ ఇన్ ఎ ర్యాషనల్ మేనర్. ఇట్ హిట్ ఎ కార్. సో ఇతనికి బాగా దెబ్బలు తగిలి ఏ పూల్ ఆఫ్ బ్లడ్ వాజ్ దేర్ ఆన్ ద స్పాట్. ఇమ్మీడియట్లీ పోలీస్ కేమ్, రిమూవ్ దిస్ ఇంజూర్డ్ పర్సన్ టు ద హాస్పిటల్. And at that time a tram was coming. In this tram a fish woman, అంటే చేపలు అమ్ముకునే అమ్మాయి, Mrs. Bournehill, she was there. Actually the driver told that some accident has taken place, let us see, like that. Then he stopped the vehicle and asked the people to get down. So after getting down, Bournehill, having seen the pool of blood, రక్తసిక్తమైన ఏరియా అని చూసి, then she suffered nervous shock and she has given birth to a stillborn baby. But please remember, the court held that Young need not pay any compensation because, please remember, because of her mental weakness, she suffered this nervous shock, not because of the accident. Of course, the accident has occurred, the willow was removed, only blood stains were there. So the blood stains were not wiped out. So this is the main case, negative case. Then I think the one case is that Dooley versus Carmel Laird and Co. Limited, 1951. So here Dooley was a crane operator. He was operating the crane, and of course the rope connected to the crane, actually he has to lift the material and put it in the ship. So in between, when it is moving, in between some workers are there. He found that the rope is weak, it is loosening, taka taka sound vastundi. Then this is moving on. Then he got a doubt. People are there underneath this so-called. So definitely if it falls down, definitely the people will die. So luckily, even though it is weak, it has gone up to the hold of the ship and it has unloaded the luggage. But in the meantime, he got nervous shock and actually he was suffered nervous shock. Now he filed a case. Injured, So he was under the wrong impression or that other workers are going to die, and therefore he suffered nervous shock and he died. So the plaintiff claimed, of course his son claimed against the company. Of course company said, since there is no injury, how can we pay compensation? That too is not in vicinity. Please remember, here the court held that since the company did not give him a tough rope, since it is provided with a weak rope which is likely to fall, so it is negligence on the part of the company. At the same time, there is a very likelihood for him to get the so-called nervous shock. Therefore, compensation has to be paid to him. So these are the important cases on the nervous shock. Please read them and enrich your legal knowledge. Thank you very much.